Hello? Oh, okay. Hi, everyone. Thank you for joining me today on our live discussion regarding removal of conditions in the context of marriage, going from the 2-year green card and going from the 2-year green card to the 10-year green card. I think I had a little bit of technical issues. Can everybody hear me? Okay, perfect. So let's just start again. Okay. Hi, everyone. My name is Samaya Khalik, and I'm an immigration attorney. Today's topic, just to repeat, is on removal of conditions in the context of marriage. When you are married to a U.S. citizen and green card holder, and you get a 2-year green card, and you want to transition into a 10-year green card. So some people may not know this, but there are actually 2 green cards that you can get, 2 types. One is conditional for 2 years, which you cannot renew, and the other for 10 years, which you can renew. So removal of conditions is the process by which those people who have the 2-year conditional green cards have to apply for the 10-year green card and show that they're eligible for it. Otherwise, when that 2-year green card expires, they will not have another green card, and their permanent residence will also expire. So what is the context in which somebody receives a conditional 2-year green card? This generally happens when a U.S. citizen or green card holder marries someone and they apply, the U.S. citizen green card holder applies for their spouse, and at the time the green card is granted to them, their marriage is less than 2 years old. So this means that once they get that green card, the USCIS, they want to know that the person who got married to the green card holder or the U.S. citizen and the other way around, they didn't get into that relationship and have that marriage for fraudulent reasons. And they want to make sure that the marriage is in fact true, and either you're still married to that person, or there are some situations that have arisen, but that still make you eligible to get a 10-year green card. So that's the main reason why this condition exists on the 10-year green card. It's to prevent fraudulent marriages, to make sure people aren't just getting married to get the green card. And it's very, very important that whoever has that 2-year green card applies to remove the conditions. When do you have to apply to remove the conditions? So if you're someone who has received a 2-year green card after your spouse has petitioned for you, 90 days before the green card expires, within that 90 days, you have to petition to remove the conditions. And when I say petition, I mean that you and your spouse have to put together a petition with your joint petitioners and submit documentation to USCIS establishing that you have been married in the last 2 years, you're still living together, and you have a relationship. And it's very, very important that you submit this timely, and you submit all the documents that are needed and as much documentation as possible so that this gets approved. If you don't submit this and apply to have the condition removed within the 90-day period, you can face having the green card taken away. There are immediate consequences. Your permanent residency will expire. You could be placed in removal proceedings. There are other serious consequences as well. If you don't have something else to be eligible for when you're in removal proceedings, you can also be removed from the United States. That's a severe consequence that could happen. So there are various consequences for not filing to remove the conditions on your 2-year green card. And of course, the most important to you should be the fact that you will lose your permanent residency and not be able to get a 10-year green card. So it's in your interest, as soon as you see yourself getting close to that 90-day period before the green card expires, to apply to remove the conditions. So how do you do that? How do you apply to remove the conditions? Well, one thing is you can work with an immigration attorney, and they will put together the form, the I-751, along with the documentation. You pay the fees and you submit that to USCIS. What happens when you submit that to USCIS? You will get a receipt from the USCIS, and you will also get an extension on your green card status while that application is processing. And the reason for that is currently it's taking a long time for USCIS to process these applications, removal of conditions petitions to get the 10-year green card. Before it was taking about 18 months, so they would give you the 18-month extension, during which time you can travel and you can work. But now, due to delays, it's been extended to about 24 months. So the nice thing about that is that USCIS recognizes that it's taking a long time for them to give you that 10-year green card to make a decision on your petition. But in the meantime, you can still work, you can still travel, and you don't lose your green card status. Another important thing to remember is you don't lose your green card status unless there is an actual denial of that petition. And you get some decision. So don't freak out, don't be stressed if that new green card, 10-year green card doesn't come in and you don't get that approval right away. You have to wait for the actual decision. So in some situations, of course, if you're married to your spouse, they will join petition with you. But what happens if, let's say, you're in a relationship with someone and you're about to get a divorce, or it's not going well? There are some exceptions. You can still apply to remove the conditions on your application even without your spouse. If you're in the middle of a divorce, you can submit that, and once the divorce is final, you can submit documentation of the judgment of divorce showing that you are in fact divorced, but you do have to establish that the original marriage was based on good faith and it was a real and true marriage. If you are already divorced, then that's great. You can submit the judgment of divorce, and that is an exception, and you can submit that with your application. There is also a situation in which someone is married to a U.S. citizen or green card holder, and they're facing extreme abuse, or they've been the victim of abuse, and the spouse does not want to apply to remove the conditions on their green card with them. That is also an exception, and you can get a waiver for that. So if you find yourself in that situation where you have the 2-year green card, you know it's about to expire soon, and your spouse is threatening to not file the petition with you, and you are being abused in other ways, you can still file and apply for the abuse waiver. Another exception is if you will face extreme hardship if the petition is not approved. So this shows you that there are various situations in which USCIS will still consider your petition to remove the conditions on your green card and grant you the 10-year green card, because they recognize sometimes marriages don't work out, but this doesn't mean the original marriage wasn't a real marriage and that it was done in good faith. So keep that in mind. If you're concerned about applying for it because you find yourself in one of these situations, speak with an attorney. They will help you to put together documentation that you need to be eligible for one of these waivers. So the next thing is, I talked about having to apply for this within the 90-day period before the expiration date on the 2-year green card. What happens if you don't file within that time? Well, if you never file, then of course your green card will be terminated and you will face certain consequences, such as being placed in removal proceedings in addition to having the green card taken away. But if there are some extenuating circumstances or exceptional circumstances that led you to not apply in time, you can still apply later and show the reasons for why you failed to apply to remove the conditions within time. So let's say a week has passed after your green card has expired, after the 90-day period. Maybe it's 3 months later, and if USCIS still hasn't sent you anything, don't delay. Put together an application and send it out, and show them the reasons for why you delayed in sending the application. We do have situations where sometimes people applied on their own. They failed to submit the necessary evidence, and they failed to send it timely. Or there was some medical situation, or they were out of the country. And in all of these kind of situations, we put together an explanation of the reason why they failed to submit the petition in time, and provided supporting evidence, and the application was approved. Another thing to keep in mind is if you don't submit sufficient documentation in the beginning to USCIS, they will send you something called an RFE, a request for evidence. And that is another opportunity for you to send more documentation to USCIS. It's great if you can submit as much documentation as possible in the beginning to avoid getting an RFE, because that just leads to some delays. But if you do find yourself in that situation where you have an RFE, don't be deterred. It's another opportunity. Gather as much documentation as you can and get the help of an attorney to put everything together and send it to them. What USCIS wants to see is documentation. You may know that you're married, you may know that you're in a real marriage and living together with someone, but an USCIS officer doesn't know that unless they see the paperwork. So what I say to everyone and to all our clients is, put all the documents together in the beginning, because you will have to submit all of those things anyways. And once you do that, they will most likely approve it. There shouldn't be any reason why your I-751, which is the form, and the application to remove the conditions, or I keep going interchanging between petition and application, but why the petition shouldn't be approved if you submit all of the documentation. Even if you find yourself in one of the previous situations I mentioned where your spouse doesn't want to petition with you, with the proper documentation, that petition should be getting approved. Let's say there's a situation where it doesn't get approved. If that's the case, I recommend contacting an immigration attorney. They will be able to put together the documentation that you need to either file an appeal or a motion to reopen or reconsider, which means they will be asking USCIS to look at the new evidence and make a decision on the petition again, or they will help you to file a new petition with the proper documentation that you need. So the important thing here is that this is the kind of situation where you have many opportunities to put together the correct documentation and get the petition approved. All right, so let's talk about what kind of documents do you need to submit. You need to submit documents that show that you are married to this person, you've commingled your assets, and you are living with them. So bank statements, tax returns, photos of the two of you together, getting affidavits from people that know the two of you, attesting to you living together and being in a real marriage, insurance, if you have children together. These are all various types of documents and evidence that you can submit to USCIS. Make sure that you submit sufficient documentation. If you don't have a joint bank account, don't worry. If you have individual bank accounts and you are sending them both to the same address, statements are coming to the same address, you can still submit that as evidence. Additionally, there are a variety of other creative ways in which you can show that you are still married to this person. The nice thing is that for the petition to remove conditions, you don't need to submit as much documentation as you need to for the marriage interview, but you still need to submit sufficient enough to show that you are in a real marriage and still married to this person. With the petition to remove conditions, sometimes you may be called in to get an interview. This is not always the situation. For the majority of our clients, we get the petition to remove conditions approved without them having to go in for an interview. So maximize your chances, reduce the possibility of you having to go in for an interview by sending a strong petition in the first place, so that one day you can just get that approval letter and that 10-year green card is going to come into the mail. That's really, really important. Another thing to keep in mind for you is when you're applying for the petition to remove conditions and you're married to a U.S. citizen, it's possible that your petition will still be pending and you may be reaching the third year of your third year of having permanent residency. If you get to that kind of place, you may be eligible to apply for citizenship while that petition is still pending. So you end up saving some time. So that's something that you may want to speak with an immigration attorney about, how you can apply for citizenship while you are waiting for the 10-year green card to come in, because that is a great option for people that many people are not aware of. So I highly recommend speaking to an attorney if your petition to remove conditions has been pending for a while and you see that it's almost been 3 years since you got married and got that green card, 3 years from getting that green card. You may be eligible to start your citizenship application and then get a decision on both at the same time, which saves you a lot of time. All right, so I think I provided a lot of information so far about the petition to remove conditions to go from the 2-year green card to the 10-year green card. Does anybody have any questions? Okay, We received a couple of other questions beforehand, so let me just answer this. Okay, can I include child dependents on my petition? Yes, if your children, when your spouse petitioned for you and they also petitioned for dependent children, and they receive 2-year green cards, then you need to also petition to remove the conditions on their green cards, and at the same time that the parent is approved, the children will also get approved for the 10-year green card, and they will get that as well. As a conditional green card holder, do I get a work permit? So keep in mind that when you have a 2-year green card, you have a green card. It's not a work permit. It's a green card which grants you permanent residence. It gives you the ability to travel, to work. So while this petition is pending, you're going to get a notice that says that you will be able to travel and to work. So you have that, and if you decide to travel outside of the United States, you can take that document with you. You can show that and they will let you back in. You can also send that to your employer and there shouldn't be any issues. And again, you don't lose your permanent residency unless there is an actual decision saying that they have denied it and you have lost your permanent residency. What should I bring for the removal of conditions interview? So some people may not even get called in for an interview. They may just send you the green card in the mail, which is amazing if you don't have to go in. But if you do have to go in for an interview for the petition to remove conditions, it's a little bit similar to the marriage interview. You have to bring in documentation to show that you're married to your spouse, or if you're applying on the basis of a divorce waiver, an abuse waiver, or extreme hardship waiver, bring in documentation to establish that and be prepared to answer some questions about your marriage. And you definitely want to bring in documentation to show that the initial marriage was real if you're doing it on the basis of a waiver. And if not, you're still with the spouse, bring in documents that you submitted to USCIS and some new documents since the time the petition was submitted and it has been pending. I think one more question. Can I appeal a denial of a removal of conditions? Yes, as I mentioned earlier, depending on the reasons for the denial, they will give you an opportunity to appeal it. You usually have to send that in within 30 days, saying that you're going to appeal it and on the basis of what. And if for some reasons the date on that passes, or it's just not a good decision to appeal, it may be better for you to reapply again, and immigration attorney will help you to kind of make that decision, and you will have another opportunity to send in your petition. So you can appeal and you can send in a new petition, which is a really great option, and it's really nice. All right. I think these are all the questions that I received. Does anybody have any more questions for me? Okay, so if there are no more questions, I will sum this up. Again, you get a 2-year green card when you are married to a U.S. citizen or green card holder, and at the time you receive the green card, the marriage is less than 2 years old. So that means that for the 2 years, when you start reaching the end of the 2 year, within the 90-day period before the expiration date, you must apply to remove the petitions, to remove the conditions on the 2-year green card by filing a petition to remove conditions so that you can get the 10-year green card. I hope I addressed all of your questions for the petition to remove conditions. If you have other questions about this, you can contact us, and you can also go to our website at www.kaliklaw.com to learn more. Additionally, we have a blog post on our website and podcast talking about the removal of conditions and other various immigration issues and questions that you may have. So I invited you all to visit our blog, our podcast, and you can sign up for our newsletter on our website where you'll get updates on immigration and important information about different petitions and visas every month. Thank you for joining me today. I'm very excited that you are all able to join in and learn about removal of conditions, and I look forward to having you all join me on our next live discussion. Take care and have a good night. Oh, 1 second. I was just about to say good night. I see that there are 2 questions here. One last question. Can this process be expedited? No, I'm sorry. There's no way to expedite this process. You have to just wait. And in recognition of the fact that this takes a long time, USCIS does give you that extension on your status, which allows you to work, to travel. So there's no way to expedite. You just have to wait until they are ready to make a decision on your petition. So I'm sorry to leave you on this note, but the good thing to know is if you send all the documents that you send, there really shouldn't be any reason why you don't get that petition to remove conditions approved. Thank you again all for joining me today. Take care and have a good night.